Why most bankruptcy attorneys struggle with cash flow. Larry Friedman, former director of the U.S. Trustee Program. Larry, good to have you.
Pleasure to be with you, Phil.
So, Larry, we work with hundreds of firms around the country, and cash flow is always something real, especially when bifurcation came 5, 6, 7 years ago. All of a sudden, people were like pulling home equity lines of credit out to see what happened. And it's not just for the bifurcated cases, but when someone really wants to leverage their bankruptcy practice and scale it, cash flow is real, right? So that's what I want to unpack today. And how do you want to unpack this?
Well, I'd start with the chicken and the egg, right? That's the problem you're describing. You want to grow your practice, but that takes funds. Someone could sign up with 720 strategy systems, get all kinds of leads, have lots of cases. And who's doing the work? Who's going to get them done? Who's going to get them out the door? Because if you can't scale your business, you can't grow it to the potential that it has.
The struggle we have is that people need to pay on payment plans, right? So you
Right.
can you can pay all this money for the lead. The lead costs is sunk up front. The initial intake, you're doing it all, and they're paying $100, $200 a month, $300 a month. Hopefully, you get 1 out of 5, hopefully 20% pay in full, but that doesn't really happen. So this is the chicken and egg. I like that like metaphor.
Yeah. And I'll just tell you that we'll get into our product and our platform, but we like 90%. We like to see 90% pays,
Mhm.
and we're growing at
And
an
when you
enormous
say
rate.
90% pay, you're saying of the people that start and retain the firm.
I'm saying of the total amount of receivables that are out there,
Mhm.
we're going to collect 90% of them.
So great. So Larry, let's unpack this with InVoygo. So InVoygo fronts fees for the attorney, right, to help cash flow. Now, does this can this work with people that do not bifurcate and just do a layaway program?
So it's certainly possible. I mean, there are a lot of law firms out there, big ones, that take in leads and tell people, look, just stop paying your bills and pay me. And they're paying a couple $100 a month and they get 10 months in, the $2,000, and they file the case.
Right.
Sure, we can manage those receivables too. All we are is a receivables management company that, in addition to that, we can offer cash on like a merchant cash advance basis. The difference is, and the beauty of it is, we don't require any personal guarantee from the law firm, none. There's a competitor out there who's blown up now who is suing lawyers. I don't think it's a good business model to sue the lawyers that you're trying to get to sign on. So we will never sue a lawyer,
Mhm.
ever. If your portfolio of accounts is not performing with us, we're going to sit down and show you that
Mhm.
quarterly. And we're either going to make some adjustments and get you to a point where they're paying, or we're going to have to go a different route. But no personal guarantee from the law firm, none, no
That's
risk.
been right.
And
Okay,
that
so
includes on the merchant banking fee. So we're going to take a flat fee for the whole contract. We never charge a late fee. We never charge a client a late fee. We never charge an onboarding fee. There are no fees other than the merchant banking fees, and we pay 100% of those. So I'm not just talking about the 3% it costs you on per transaction. To have a merchant banking account, you have to have a merchant banking account, which has quarterly fees and maintenance fees. And all. We pay 100% of that, a
so
hundred
so
percent of it.
okay, that's fantastic. So let's unpack this really practically.
But let me just get to
Yeah,
the
yeah.
money though,
Sure,
Phil.
sure, sure.
The 1,100 bucks. As you're building your practice, somebody has to do the work. The lead costs money. Your paralegals cost money. You got to pay, rent and phones and software and all of the software licensing fees and all of those things. What you learn to do is to perform the bankruptcy based on the 50% cash advance that we give you. The rest then is all gravy for you.
Let's unpack this. So it doesn't matter if you bifurcate and some obviously just for clarifying for people who don't understand, maybe new lawyers in this, a bifurcation is when an attorney files an emergency petition and then collects payments post
Post petition,
petition
because they're non-dischargeable.
because they're non-dischargeable. That's one option. Option two are when a person does not bifurcate and they just do the normal pay in full and then we'll file your
Right.
case.
So in that case, you're not using our cash.
Mhm.
You're accumulating the cash up front,
Right.
but you're using us to manage the receivable for you. And
Right.
we are very good at it. And our platform is as slick as anything out there.
Are the prices the same both ways, or is there?
We charge. Yeah, we'll charge you the same either
Oh,
way. Well, yeah. Hey, so a lot of those people who are paying you monthly don't actually file. So it gets a little complicated because you got to refund that money or, or whatever you're going to do with those people. And there wasn't like a set contract, right? I can't take a fee on a set contract. They drop out. I've
mhm,
got my fee and you didn't get anything out of it.
right.
So that part of it is a little more fungible.
So like let's start with point two. Let's just pretend I'm a debtor attorney in fill in the blank that doesn't bifurcate wherever that is, right?
Hmm.
Or I'm not bifurcating, and
Hmm.
I set someone up on a $200 per month fee, and it's for 10 months for $2,400, right?
Hmm.
What would InVoygo charge me to just manage that debtor but not advance any money?
We like to look at the person's portfolio to see how it performs
Okay,
and give them a number. So I can't just give you a number, but it
okay,
would be in the single digit number. So
okay.
we don't have the cost of capital, which is
Uh-huh.
the most expensive piece.
Hmm.
So you're in a number that's, 3 to 6%
Okay,
of collections. Yeah. And
okay.
we're just going to
So
take it from collections.
So if the 3%, if law pay is what 3 to 4%, you're a little more, but you're managing the whole thing. You're
And
not
we put it
the
on a platform for you.
right, and as opposed to the debtor attorney going in and managing that. Okay, so if they want information on that, they can contact you, and you'll price them based on their receivables and volume or
And
whatever it
how
is.
they've performed in the past if they have any data. That'll
Okay,
help.
great. Okay, second thing, let's pivot to bifurcation because this is where you're actually advancing money in advance for the debtor attorney to scale. I mean, we actually talked about this yesterday. We had a client from Michigan, right? And they needed the advance funding to make this happen. We referred to you, they
Hmm.
signed up with you, et cetera, et cetera. When you are pre-funding, first of all, let's build the framework on why this is legal because there's a lot of we know in the industry factoring was frowned upon and many times judges thought that was fee sharing. Speak as the former director, U.S. trustee, why you frame this company this way and why it works.
There were two major problems with bifurcation that the program attacked. The first was the factoring component. In a factoring component, someone advances you cash against a receivable and then they own the receivable. That's an ethical problem. You cannot tee your client up to a third party who might sue them even to collect the money or do whatever they're going to do to collect it. And in return, you did that so you could get paid.
Mhm.
That creates a conflict between you and the client. You're not acting in the client's interest, you're acting in your best interest. You did it so you could get paid. That's a problem. The second problem, when you bifurcate, you're doing a certain amount of work up front. You have to figure out the means test because you don't know if they're eligible for Chapter
Mhm.
7. So
Right.
you have to do some work in order to figure out the means test. But you really need to do a little bit more because you don't need something coming along after you file the case that means it should have been a 13. You got to convert it. It's a nightmare, whatever. So you do some work up front, you file the case. The client comes back in, signs a second retainer agreement, and then you do the rest of the case, the schedules, the SOFA, everything else you need to do to get that case queued up for a 341 hearing and a discharge, debtor education, all of that stuff, right? Because when you file an emergency case, they don't even do the debtor education yet. They got to file a
Right.
case and then do the debtor education within so many days,
Right.
right? So what the U.S. Trustee Program said is nonsense. You're creating a legal fiction. You had to do basically the whole case
Right. Right.
before you filed it. So don't tell us that you spent 20% of the fee up front and 80 on the back
Mhm.
end. You did 80% of the work up front and
Mhm.
20 on the back end.
Yeah. Right. Right.
That got litigated all over the United States.
Many, many places.
17 cases that I know of, there's probably 50 now.
Yeah. Right.
And the end result was there were a lot of judges who said, look, here's the problem. These people need relief. Bankruptcy, when I was a trustee, $300, $350, the filing fee was like $35, which basically was the trustee's fee. Today, the average bankruptcy is $2,000
Yeah.
for Chapter 7. We talked about this yesterday. Client comes into your office, you explain the whole thing. All I need is my $2,000. They're like, what part of bankruptcy don't you understand?
Right.
right? So that's the problem that we solve.
Right.
So this was litigated all over, and ultimately the U.S. Trustee Program came to a memorandum of understanding or a policy directive that they put out. It's public. I'll send it to anybody who contacts you and wants the
Let's include
information.
it. Let's include the link in the description here.
We can include a link in the description to it. And it basically sets the four corners of if bifurcation is allowed in your district by the judges, the program will no longer challenge it. But if you're using a funding company, the program still has concerns and they want to know about it. And their concerns are the factoring issues, the collection, how the consumer is treated. We've solved all of that. Why? Because I know how to look at it from the consumer standpoint. I understand the regulatory framework.
And how did InVoygo solve that? Because that's going to solve the cash flow problems that attorneys are facing.
We don't take any interest in the receivable.
Mhm.
Our platform sets you up with your own law firm and your own law firm receivables. It's white labeled for your law firm. Yes, InVoygo's there in the background doing the work behind the scenes, but this is you extending terms to your client. You never give up control of the receivable. You never give up ownership of the receivable. If the person doesn't pay, it's your decision what to do with it. It's not our decision. We don't own the receivable because we have the way our program works. We look at these as a pool of accounts. So we
Mhm.
base our program based on how your pool performs. So if you would think the person's good and you want to extend them terms and you think they have a good flow to pay back the receivable, you should use us and you should sign them up and we're going to manage it. We manage it on a very soft touch, mostly text, emails. We have a platform for the law firm where they can see every law firm, every account they have and how it's performing, what the terms were. They can see every touch we make to them if we put notes in the consumer in the CRM system. And the consumer gets a portal that they can see on their phone, just like Chase or Affirm or Sheffield Finance. And they can update their card. They can push their payment. They missed a payment. They can make a payment. They can make a partial payment. They can basically self-service. And then for
And
those who need more, we still take calls and texts.
the money goes into a bank account that the debtor attorney owns, and it's their name.
Yeah. Well, yes, we set up a merchant bank account. The funds go from the debtor to that merchant bank account.
Mhm.
They are auto forwarded to our account because we're collecting the entire receivable.
Got it. Okay.
But the relationship, so we solved it because the relationship between the law firm and the client didn't change. The client's making payments managed by InVoygo to the law firm.
Mhm.
And then we capture those because we have this cash advance part and so on and so forth.
So let's take a practical example. A person comes in to file a bankruptcy and they agree to a $2,000, let's go back to my original example, $2,000 Chapter 7 bankruptcy, $200 a month for 10 months. What type of advance do you give the debtor attorney? How does this work?
They have two
How's
retainer
that?
agreements.
Two agreement. Okay.
So they sign a retainer agreement up
Hmm.
front with the firm. And our suggestion is they should get the filing fee and a little bit more upfront.
One little more,
Why?
let's define a little bit more.
$500 total. So
Okay.
338 for the filing fee and $163 or whatever that
Right.
is.
Okay.
That's the upfront retainer. The case gets filed, the filing fee gets paid. What that does is it avoids the situation of paying the filing fee in installments. You know that under the code, you could pay the filing fee in
Mhm.
installments, but you have to file a request to do that.
Okay.
And under the guidelines and the law, you can't take any fees before you do that. So if
Mhm.
you were to do a true money down and like advance
Got it.
money,
Got it. That's the problem.
ethical problems all over the place. So you
All over the
should get the
place. All
filing
these
fee up
red
front,
flags.
a lot of red flags. So you
Okay,
should get
so
the filing fee.
so let's take that $2,000 example. The debtor comes up with $500, and I mean, the no money, the true no money down was really popular probably 4 or 5 years ago. Now it's not. Like I only know one attorney nationwide that is doing that, a true no money down. But let's just say $2,000, $500 down. That's $1,500 that's going to be collected post petition. So
Right.
if I just take that and let's just say the debtor attorney agrees to $150 a month for 10 months.
It's going to be a 10-month contract because
Okay.
that's what we like.
Okay, you like the
So
10 month. Okay, so that's a good point. Let's before we go closer. why do you want the 10-month contract? And can we, if attorney want to do 6-month or 12-month, would you allow it?
Well, shorter, of course, we'll allow shorter because we get our money back faster. We don't
Okay.
change the fee. So that'd be a layup.
Okay.
It's longer, that's the problem. And the problem is in building this model over 3 years and testing the financial model, performance is affected by 100 things, Phil. It took us thousands of hours to build this. 10 months is the sweet spot. So we ask that you only do 10-month contracts.
Okay. So
Now,
a
you can
little,
pay
all right.
monthly, weekly, biweekly.
So I want to point something out, and this is something this is just information for the debtor attorney. The most important thing is don't sell based on the 10-month. Sell based on the monthly payment that the
Yeah.
debtor can afford. And what I mean by that, in using my example, initial $2,000 divided over 10 months, $200 a month. If the debtor can afford $200 a month, it's better to stick at $200 a month and pay that $1,500 off in 7.5 months. You get
Right.
your money faster. The debtor's not thinking about it. There's less things for to go wrong in the debtor's world. And but a lot of debtor attorneys don't understand the importance of selling the payment, right? You're giving freedom to a debtor, a client, and all you're doing is basically saying, "Hey, what can you feel comfortable paying?" They're no longer paying all their debt.
Oh, let's say they're right. Let's say they're paid weekly. Here's the other side of that, right? $55. Can you afford $55? Okay.
Absolutely.
$55 over 10 months weekly, $2,000.
Yeah. I mean, it really is. That's even a better point, Larry. If they get paid weekly, take it out on their payday, a small amount, something very reasonable. Debtors as a whole, they need to be coached in. They need to be trained on here's how we're going to do it, and they appreciate the guidance. So, okay, I love
And,
that. So,
and when we do our guidance, Phil, to that point, you can set up on our platform, you go in, blah, 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 I'll show you, we set up, a payment plan. The important thing to do for your clients, for your firm clients, is to get them in the habit of getting that first payment scheduled quickly
yeah. Well, I mean, not just quickly. I
because
mean,
they
it's
need to get in the
yeah.
habit of seeing that payment. They can't wait 30 days
Oh
like,
no.
oh yeah, I did that.
Yeah.
If the first payment, if you're doing it monthly, we'd like to see the first payment date within 21 days. If you're doing it weekly or
Right.
biweekly, we want to see it within 14 days so that the debtor gets accustomed to the payment coming out of their
It's
account.
absolutely critical. I have a video on our YouTube channel on James Howson, who you know. 3 years ago, he was collecting $3,000 a month in attorney fees automatically through his law pay account. Now it's over $100,000. And I asked him why. And he gave me two reasons on the video. One of the reasons is because he will not take on a client without a lockdown payment plan right now, like on the call. And if not going to take his client. And he has grown from obscurity in Ohio to the number two filer in the state. I mean, it's just a real huge success story. Watch the video. Going back to that $2,000 Chapter 7 fee, $500 down. You said collect the filing fee and a little more. So we're going to say $500 and let's just lock that in. $500 on whatever the
Mhm.
for the down. Then you take the $1,500. It can be as little as $150 a month, broken weekly, bi-weekly, monthly, whatever it is. And what does the the debtor attorney get advanced of that $1,500?
50%.
50%. Okay. So they get $750 up front, right? Right out of
Plus
the
the
gate.
ones plus the 170 they got from the 500.
Right.
So they're getting
So it's
right. So add those.
$830.
So they got to keep their costs to do this petition under $830,
Okay.
right?
Right.
Roughly.
Right.
If they
So
do that, they're going to make a ton of money.
so if the $2,000 we're talking about, because we're talking this example included the filing fee. A lot of attorneys put their filing fee over and above, and your advance would change accordingly. But in this example, the $2,000 includes a filing fee. So the attorney fee would be 1665.
Okay.
So how does it work after that? If we're counting $150 a month for 10 months,
Hmm.
That's $1,500, right?
Right.
So they received 830, and then there's
We
670.
also we also advanced our fee,
Okay. Okay.
right? So I like to do the math. Just I hate to do this to you, Phil, but it's easy if you go with a $2,000 post-petition contract.
Okay.
Okay. $2,000 post-petition contract, the fee is 18%. So we're going to give you $1,000 and we're going to advance the $360 fee to ourselves.
Okay.
After we collect the 1,000 plus the 360, the 1,360, which is about the middle of month 7, if you keep it on a 10-month contract, every dollar after that goes into this tail that we're building for you. And that reserve grows, and then you get money back out of that in a number of ways that we work it out.
Okay.
But 100, you're going to get 100% of
So
that
what I'm hearing,
32%. Right.
what I'm hearing is InVoygo's fees are 18% of the contract amount.
That's right.
Okay. So in other words, just sticking with our example, because we're working on it, on the $1,500 um, contract, you're gonna the fees are gonna be the attorney will get back $1,230 of that, and the fees to InVoygo will be $270 of the $1,500.
I'll trust you on the math.
Those are the numbers.
Okay.
Okay, so 18%. So
Right.
basically, it's you're for that 18%, you're getting advanced
You're
money
getting
with
cash.
cash without a personal guarantee.
Right.
You're completely compliant from a legal perspective.
That's
That
right.
includes all payment processings, your staff,
Merchant merchant banking fees,
merchant banking fees. You have
all of it.
someone who is
Access to our
emailing.
platform,
Yeah.
the consumer portal for the platform, everything.
But more importantly, you have someone, if you're late, they're contacting them. If
Yes.
the person says, hey, I'm not working this week and I need to skip a week, they contact you, not the debtor attorney.
Right.
Okay.
Right.
So, okay, well, that's good to know. That's great. Okay, that's good to know. So basically, in this,
We have that every day.
yeah.
People call
So
us, "Hey, I'm out of a job. My mom's
every
in the
day,
hospital."
every
Yeah,
day, 100 times a day.
yeah.
What are you
Right.
talking about?
Right.
Dude, we're
Right.
dealing with debtors.
Well, because we've built this consumer portal, it doesn't happen 100 times a day.
Oh, got it. Right.
199 times a day,
They go
people are
online.
using the app to go online and fix it. If they need to push a payment, though, or change a payment date, we do that for them.
Another thing I want to point out, I'm assuming the answer on this, but just clarify it. This is not an all or nothing transaction either. I mean, like if I'm a debtor attorney and I'm doing 25 filings a month, I could do 15 with you and keep 10 on my own.
Sure.
It's completely beholden or it's all the powers with the debtor attorney.
We charge you nothing to be on our platform. Now, the only caveat with that, I'll say, just I'm a lawyer, right?
Yeah.
Disclaimer. If you were bifurcating 50 cases a month and you wanted to give us half of those because you want to try to do it yourself, maybe, or learn how to do it, whatever, manage them yourself. You want to test us, champion challenger. How good are these guys? Can I do it better? That's fine, unless we don't want people who are going to cherry pick them.
Okay.
They say 10 people and they're like, these 3 guys are going to pay, but I'll give them to InVoygo and I'll get $3,000. Attorneys tend to play that game sometimes,
Yeah.
and we frown on that.
Well, let's
Other
talk.
than that,
Let's talk about this because qualifying the debtor is real. I mean, you brought up BK billing before in the old Wild West days. I remember those days.
mhm,
They were like, no qualifying. We will fund anybody, and that
that's right.
didn't work, right? Do you have qualifying criterias of what you
So,
recommend for the? I
so
mean,
we
it's up to
don't,
the attorney. I mean,
yeah. So you hit on the right thing. We got there because it's important that the attorney be comfortable. It's their receivable.
right? No, right? Yeah,
Don't
no, yeah.
send it to us if you don't think the person's going to pay, because we're going to ding you on the back end of it because we're holding that 32%. Don't forget, right?
Without a question.
Right,
Without a question. And
right.
this is an
So,
important distinction because
yes,
you do not want to you never want to do this type of bifurcation or lend money to someone if you don't trust in them. I mean, like,
that's right.
you know,
That's right.
one of the things we played around with at 720 System Strategies with this disclaimer of asking people, hey, do you want your payments reported to the bureaus? And
Right.
if they and you tell them we can do it if the if you're willing to pay $10 a month to the bureaus. And it was like a proxy. It would just say, I
Right.
want to see what the client answers.
Right.
And if
Right.
they say yes, oh, these are good debtors. They care. They're willing to pay for their
They
credit
want.
improvement. But if they say no, red flag. Like
Yeah.
these people don't care
Right.
about their credit. So the point of this is for the debtor, for if you're a debtor attorney, no, this isn't about like just getting an advance. It's about putting right people in. So let's talk about that. Let's just say the attorney in good faith puts someone in,
Right.
and then it's the first payment default.
Right.
Like it's
So.
a horrible debtor. Like the debtor doesn't care. They file their petition, their emergency petition, and they ghost the attorney.
Mhm.
What would you do
Yeah.
as an attorney if you were that person?
Yeah. Well, that's the question,
Mhm.
right? If we've already advanced you the money, again, we're not coming back to you for it because we did it on an unsecured basis.
Mhm.
We told you that. We're going to live by that, right? But you wouldn't want too many of those because we're not going to do too many of those,
Right, right.
right?
Yeah.
Right.
Well,
So,
but like with the attorney, if that happened with the attorney, can the attorney back out of that case, or because they filed the
well,
petition, are they legally obligated to take it all the way through?
well, I mean, I don't know that you're getting into bar rules
Okay,
and
bar.
local
Okay,
rules
got
about
it.
whether or not the attorney can get out of the case because
Okay,
they're
got it.
ghosted. That's a
All
whole
right,
nother problem. As far as our transaction, we've had attorneys come to us and say, "Hey, let's back it out. This is no good. I'm sorry. I'll give you back the $1,000,
right,
back
right.
out the deal." Of course, we'll do that anytime. But as far as whether or not the client is going to pay or not, I mean, we don't underwrite the individual debtor. The reason we don't do that is because if you were to underwrite some of these debtors, let's say they're on Social Security, let's say they're me broke on Social Security, and all they have is their Social Security payment, and let's say that's $2,000 a month.
Mhm.
Okay, if you were underwriting that debtor on a $2,000 loan over 10 months, and they're only making $2,000 a month, and they got to buy food and heat and utilities, and they have a wife, that's not going to work. We would write that advance anyway. And we write it because Social Security people tend to pay very, very well.
Got it.
They're terrific payers. So we have other factors that we look at. And
Okay.
primarily those factors are, is there a cash flow that the debtor has monthly that
Mhm.
they're going to be able to access to pay this attorney advance off?
Mhm.
That's the criteria.
Got it.
It's totally different from typical lending because we're not lending.
Yeah.
Right.
Larry Friedman, InVoygo. How do people get a hold of you, Larry?
Larry at InVoygo.com.
Thank you, Larry.
My pleasure.